A major court ruling this December just shattered everything you thought you knew about gun rights in America. And if you own a firearm, you need to hear this right now, because 10 critical laws have been completely rewritten overnight, and the government isn't making this easy to understand. So listen closely, because what I'm about to reveal could mean the difference between staying legal and facing serious federal consequences that could cost you everything you've worked for. And here's the shocking part: most gun owners have absolutely no idea these changes even happened, which is exactly what certain people in power want, because when you're uninformed, you're vulnerable, and that's where they have control. But not today, because we're exposing every single update that the mainstream media conveniently forgot to mention, including the most controversial changes to concealed carry permits that have Second Amendment advocates absolutely furious. And wait until you hear about the new restrictions that could turn law-abiding citizens into criminals without them even realizing it. So smash that subscribe button right now, hit the like button, because this information could save you from legal disaster. And make sure you watch until the very end, because the final revelation about what they're planning next will leave you absolutely stunned and questioning everything you thought you knew about your constitutional rights. Law number 1. Illinois assault weapons ban struck down. The Illinois assault weapons ban case is absolutely fascinating and shows how dramatically gun laws are changing right now. So let me walk you through what happened here, because it's a perfect example of the legal roller coaster gun owners are experiencing across America. Back in January 2023, after that tragic Highland Park shooting during a 4th of July parade where 7 people were killed by someone using an AR-15 style rifle, Illinois Governor J.B. Pritzker signed the Protect Illinois Communities Act, which banned the sale and distribution of over 170 specific firearm models, including AR-15s, AK-type weapons, and various semi-automatic firearms. Plus, it restricted magazine capacities to just 10 rounds for rifles and 15 for handguns, making Illinois the 9th state to implement such a ban. Now here's where it gets interesting, because people who already owned these weapons could keep them, but had to register them with the Illinois State Police by January 2024. And shockingly, only about 29,357 out of 2.4 million firearm owners actually registered their weapons, which is barely over 1% compliance. Fast forward to November 8, 2024. When federal judge Stephen McGlynn dropped a bombshell by issuing this incredibly detailed 168-page ruling that declared the entire law unconstitutional. And his reasoning was really compelling, because he argued that these weapons are commonly owned by millions of law-abiding Americans for legitimate self-defense purposes, comparing firearms to airbags in cars or lifeboats on ships, essentially saying you can't ban the primary tools people use to protect themselves. Judge McGlynn gave Illinois 30 days to appeal before his ruling would take effect, which would have essentially made these weapons legal to purchase again throughout the state. However, just days before that deadline in early December 2024, the 7th Circuit Court of Appeals stepped in and issued what's called a stay, which means they basically hit the pause button on Judge McGlynn's ruling. So the ban remains fully in effect while the appeals process continues. And this is where gun owners need to understand that even though a federal judge declared the law unconstitutional, it's still completely illegal to buy or sell these weapons in Illinois right now, because the higher court said, wait a minute, let's review this more carefully before making such a major change. The 7th Circuit's decision to keep the ban in place suggests they might ultimately disagree with Judge McGlynn's interpretation, especially since the same court had previously refused to block the law when it first passed. And this case will now go through the full appeals process, which could take months or even years before we get a final answer. And depending on how that goes, it could eventually reach the Supreme Court, which would make it a landmark case affecting assault weapon bans nationwide. Law number 2. New York private property concealed carry ban invalidated. Federal Judge John Sinatra Jr. ruled in October 2024 that New York's blanket ban on carrying concealed firearms on all private property is unconstitutional. The law made it a felony for licensed concealed carry holders to bring firearms onto any private property open to the public unless the property owner explicitly permitted it. The judge emphasized that while private property owners retain the right to ban firearms on their premises, the state cannot unilaterally exercise that right and interfere with Second Amendment protections. This ruling affects places like grocery stores, gas stations, shopping malls, and restaurants. Property owners can still post signs prohibiting firearms, but the default presumption has been reversed. Gun owners no longer need explicit permission to carry on private property open to the public. Law number 3. Domestic violence gun ban upheld. In United States versus Rahimi, the Supreme Court delivered an 8-1 decision upholding the federal law that prohibits individuals subject to domestic violence restraining orders from possessing firearms. Chief Justice John Roberts wrote that temporarily disarming someone found by a court to pose a credible threat to another's physical safety is consistent with the Second Amendment. This was a crucial test of the Bruin framework, clarifying that modern regulations don't need to be identical to historical laws, but should be relevantly similar in purpose. The court rejected demands for a historical twin and instead focused on broader principles. Justice Clarence Thomas was the lone dissenter, arguing there's no historical tradition of disarming dangerous individuals. Law number 4. Ghost gun regulations upheld. The Supreme Court issued a 7-2 decision in Bondi v. Vanderstock upholding ATF regulations on ghost guns, untraceable firearms assembled from kits without serial numbers. Justice Neil Gorsuch wrote for the majority that the Gun Control Act permits the ATF to regulate weapon parts kits and unfinished frames or receivers that can be readily converted into functional firearms. The 2022 rule requires manufacturers to serialize these components and conduct background checks on buyers. Data shows ghost gun recoveries from crime scenes increased nearly 17-fold between 2017 and 2023. Since the regulation took effect, cities have reported sharp declines in untraceable firearms used in violent crimes. Only Justices Thomas and Alito dissented, arguing the ATF exceeded its statutory authority. Law number 5. Felon-in-possession law challenged for nonviolent offenders. Multiple federal appeals courts issued conflicting rulings on whether the lifetime ban on firearm possession applies to people convicted of nonviolent felonies. The Third Circuit ruled in Range v. Attorney General that the ban was unconstitutional as applied to a man convicted of welfare fraud. The Ninth Circuit similarly found in United States v. Duarte that the prohibition violates the Second Amendment for someone with 5 prior nonviolent felony convictions. However, the Sixth Circuit took a different approach in United States v. Williams, holding that felons can possess firearms if they prove they're not dangerous. The Supreme Court has asked lower courts to reconsider these cases in light of the Rahimi decision. This represents a massive shift. More than 1,100 challenges to the felon gun ban have been filed since Bruin, with at least 30 succeeding. Law number 6. California assault weapons ban declared unconstitutional. Federal Judge Roger Benitez ruled again in October 2023 that California's decades-old assault weapons ban violates the Second Amendment. In his 79-page opinion, Benitez wrote that the Roberti Roos Assault Weapons Control Act unlawfully deprives Californians of weapons commonly owned in most other states. He compared AR-15s to Bowie knives from the 1800s, dangerous but useful tools with a long tradition of civilian ownership. The judge granted California a 10-day stay to appeal, and the Ninth Circuit has kept the ban in place during the appeal process. California Attorney General Rob Bonta vowed to continue fighting, stating that weapons of war have no place on California streets. This case remains pending in the Ninth Circuit as of early 2025. Law number 7. Sensitive places restrictions largely upheld. The Second Circuit Court of Appeals ruled in October 2024 that New York can enforce gun bans in sensitive places, including schools, hospitals, public transportation, government buildings, parks, and libraries. The court upheld most provisions of the Concealed Carry Improvement Act, including requirements for applicants to demonstrate good moral character and disclose household members. However, the court struck down bans on places of worship and rejected the requirement for social media disclosure on permit applications. This ruling clarified that states retain significant authority to designate certain public spaces as gun-free zones, even after the Bruin decision. The Supreme Court declined to review this decision in 2025, leaving the Second Circuit's ruling in effect. Law number 8. Drug user gun ban under constitutional challenge. The Supreme Court agreed in October 2025 to decide whether federal law prohibiting unlawful drug users from possessing firearms violates the Second Amendment. The case involves a man charged with possessing a gun while being a marijuana user. The Fifth Circuit ruled the prohibition is unconstitutional in most cases, finding that history and tradition don't support disarming sober people based solely on past substance use. The Trump administration argues this threatens public safety and that legislatures have prohibited drug users from gun ownership since the 1920s. More than 30 states have similar laws. This case will clarify whether categorical prohibitions based on drug use can withstand Second Amendment scrutiny, or if individualized danger assessments are required. Law number 9. Maryland assault weapons ban upheld. The full Fourth Circuit Court of Appeals upheld Maryland's 2013 assault weapons ban in a significant victory for gun safety advocates. Writing for the majority, Judge Harvey Wilkinson found the law fits comfortably within our nation's tradition of firearms regulation, as another example of states regulating excessively dangerous weapons while preserving avenues for armed self-defense. The ban was enacted after the Sandy Hook Elementary School shooting. Judge Julius Richardson dissented, arguing that the prohibited weapons are commonly owned by law-abiding citizens for lawful purposes. The Supreme Court declined to hear the case in June 2025, with Justices Alito and Gorsuch noting they would have granted review. Justice Kavanaugh indicated the court may address assault weapon bans in the next term or two. Law number 10. Large capacity magazine bans face uncertain future. Multiple states' restrictions on magazines holding more than 10 rounds face ongoing legal challenges. Federal courts struck down magazine capacity limits in several states, but the Ninth Circuit upheld California's ban in Duncan v. Bonta in 2024. The First Circuit upheld Rhode Island's large capacity magazine ban in Ocean State Tactical in March 2024. Judge Benitez previously ruled California's ban unconstitutional, but the Ninth Circuit reversed. These conflicting decisions have created a circuit split, with gun rights advocates arguing that standard capacity magazines are common and necessary for self-defense, while gun safety proponents contend they facilitate mass shootings. The Supreme Court has declined multiple opportunities to resolve this split, suggesting the issue may percolate further in lower courts before the High Court intervenes. Closing statement. These 10 court rulings represent a fundamental reshaping of America's gun law landscape. The post-Bruin legal framework requiring historical analogs has created chaos and inconsistency across federal circuits. Some bans that existed for decades are falling, while others are being upheld. Assault weapon bans, magazine restrictions, and felon-in-possession laws, regulations once considered settled law, are now subject to intense judicial scrutiny. The Supreme Court's selective intervention suggests justices are waiting for clearer patterns to emerge before resolving major splits. What's certain is that every gun owner must stay informed about these rapidly evolving legal standards. The laws in your state today may be struck down tomorrow or reinstated next month. Understanding these changes isn't just about knowing your rights. It's about staying on the right side of the law in an era of unprecedented legal uncertainty. If this video opened your eyes to how fast gun laws are changing, hit that subscribe button and turn on notifications so you never miss a critical update that could affect your rights. Smash the like button, drop a comment telling me which ruling shocked you most, and share this with every gun owner you know, because this information could save someone from serious legal trouble. Stay armed with knowledge, and I'll see you in the next one.